All right, who's here on John Philip D. McCarter?
Morning, Your Honor. David T. Arena.
Good morning. How's it going?
Good to see you.
You too. All right, court is calling. And I'm sorry, counsel, if you are going to speak, if you'll move down to that end.
Good.
All right. Court is calling 2024 CR 012474, State versus John Philip D. McCarter. Can I have parties announced for the record? State,
Megan Galloway for the state.
defense.
David T. Arena for Mr. McCarter.
And are you Mr. McCarter?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is compliance with discovery. Is this an application for deferred adjudication or community supervision?
For community supervision, Your Honor, not eligible for deferred.
So, Mr. McCarter, did you sign the document entitled Application for Community Supervision?
Yes, Your Honor.
And did you review that with your attorney?
Yes, Your Honor.
So the record is clear. The court has an application for deferred adjudication as well. Do both parties agree that your agreement is for community supervision only?
Yes, Judge.
Yes, sir.
All right, so you understand, sir, that there's no application for deferred adjudication. That's not a part of your agreement.
Yes, sir.
And you understand, community supervision is a conviction.
Yes, sir.
All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the admonishments with your attorney? Did you understand it?
Yes, sir.
Did you sign it in all the appropriate places?
Yes, sir.
You're charged with driving while intoxicated with a child under 15. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, sir.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. McCarter, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $1,000 fine. State recommends community supervision and ignition interlock for half the term. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, community service hours, DWI intervention course, VIP, and 10 days in the Bear County Jail as a jail sanction. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit number 1 and attachments.
Any objections?
No objection.
State, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
I do, Your Honor. Just for the court to take judicial notice, it is his first sin. He's never had one of these before. He's got a clean record. And
Everyone, please whisper.
and he's been extremely remorseful, which is difficult for this judge to see, but it's, I've done a few of these and he's definitely taken it seriously. So we would ask for an ankle monitor instead of incarceration, but we leave that, of course, up to Your Honor.
All right. So how often have you been drinking?
I haven't had it since the incident.
Mhm.
I have not had a drink since the incident.
All right, and how often were you drinking before the incident?
Not maybe 2-3 times a week, but not heavily and not.
All right, 2 to 3 times a week is a lot.
Yeah.
And this could have turned out so horribly wrong because you're on 35, there's construction. You have your children in the car. You drank a lot, according to this. And then the fact that you're driving around with the 18 pack of Miller Lite, they say on the floorboard and only 4 cans remaining.
Yes.
That's a lot.
Yes. Ma'am.
So are you in any type of treatment?
Not currently.
Have you received any treatment?
No, ma'am.
Okay. Was Child Protective Services involved?
That's my knowledge.
Well, who picked up the children?
My mother did.
All right, and do the children live with you?
Yes.
And who else lives with you?
I'm sorry.
Who else lives in the home?
It's me and my children.
So where's the mother?
The mother is, we're divorced, so she has her own home. Like, we split time 50/50.
All right.
And I homeschool my children too.
So what do you do for a living?
I'm a commercial plumbing estimator. So I work from home.
All right, this is what we're gonna do. The court is finding you guilty. The court is gonna sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's $1,000 fine. That will be probated. Ignition interlock until further notice. You all say ignition interlock for half a term. Any objection? Because I'm changing that part of your plea bargaining agreement. So the ignition interlock is going to be until further notice.
No objection.
So if any objections, sir? All right, so ignition interlock until further notice. Of course, at half the term, you can come back to the court. And if he's doing well, more likely than not, I'll allow him to be off ignition interlock.
Thank you, Your Honor.
There's to be regular reporting by Zoom or in person, regular random UAs, probation. Make sure there's alcohol testing with the UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's going to be field visits 1 time per month until further notice. And probation, make sure you have them check the home for any alcohol. DWI intervention, VIP. Something crazy, just 1 second. All right. And there's a driver license suspension for 180 days. There's going to be 180 sober meetings in 180 days. CAP evaluation out of custody. And probation, we'll start with intensive outpatient treatment. If they recommend outpatient treatment, I still want to start him with intensive outpatient treatment. There's going to be, I'm going to give you a choice. I can sentence you to 10 days, starting today in the Bexar County Jail for your jail sanction, or I can place you on GPS for 30 days.
GPS.
All right, so there'll be 30 days GPS in lieu of 10 days in the Bexar County Jail. And the reason why I'm doing that is because of the hardship. You have your children 50% of the time, and there's overcrowding at the jail. And also there are some health concerns at the jail.
Thank you, Your Honor.
Thank you, Your Honor.
Probation, is there anything else that's needed? Is there anything else you need from the court in order to be successful?
Probation, who do I go to for that?
Oh, they'll let you know.
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. DWIs, nobody, I've never, or at least I have yet, in all my time as a judge, all my time as a defense attorney or prosecutor, have somebody who said, I was drinking, and the reason why I was drinking because I wanted to go out and kill somebody. I've never heard that from anybody. You know what ends up happening? They end up drinking. They don't realize they're intoxicated, or either they think, it's not that bad, I can still drive. And they end up killing somebody. And usually it's the person who's just trying to get home, or usually it's the soccer mom or soccer dad or children. And if you would have hit somebody or killed somebody, this would be a whole different case. So you're one of those people who cannot drink alcohol, period.
Mhm.
I don't drink alcohol, and the reason why I don't drink it is because I don't think it tastes good. I never acquired a taste for it. So while you're on this probation, you're not allowed to drink alcohol at all. And it's not just because this is DWI. The legislature has mandated everybody who's on probation, you can't drink alcohol, whether it's in your home, at a cookout, it is not allowed. In this court, to be successful on probation, communication is key. If there is an issue, you need to let your probation officer know. If you feel you're going to take a drink, pick up the phone, call your probation officer. Because you need to figure out while you're on this probation, what helps you maintain your sobriety. You understand?
Yes, ma'am.
All right, if you have an issue, let probation know. If you feel they're not addressing it, you can always come back to court and
Thank you,
address
Your
it with me. All right, thank you. Thank you for dressing appropriately for court. Just remain in court, and probation will go over conditions with you.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome. All right, so on his cases, this is supposed to be final discovery. So where are we on discovery?
Judge, we've actually filed a discovery motion because the co-defendant of sorts was juvenile. The case has already been adjudicated. So we wanted to, and those records are not readily available to me.
Mhm.
So we're requesting information from his file.
All right.
I was brought that attention today. I don't know.
It was a
that-
recently filed motion.
Right, and I don't know if they just wanted the plea agreement or.
What are your questions?
Well, actually, I'd like to see all of it, Judge, because I don't know what I'm missing until I see it, right?
All right, so with regards to all of it, it's a juvenile. Now, I don't see where there would be any objections to seeing what the plea bargain agreement was. But other things related to the juvenile case, I'm not sure specifically what you're
Well,
requesting.
for
because it
example, I
may
don't know
not-
what if he gave a confession? What if he gave a statement? I know we're not getting into the facts, but he's the main actor in this deal. And he's pled to the ag robbers.
Well, state if you could see if whether or not there was a statement made by him. I don't know if there's, it should be reported if it's a juvenile.
Well, Judge, I know this. I mean, I think Mr. Jesus referenced it if it was given later. Because at the time of the investigation, he did not speak with police. I know that's part of the facts, but I mean, he did not speak with, he did speak with the police. So we know that there's no statement there. But I can look into one, definitely getting the plea paperwork and the steps and everything, if, I don't know how to do it over there.
Oh, well, I know sometimes, usually the person who is the main person in juvenile cases is the probation officer. Even though they're not, I don't know if he received probation or not.
He got a determinate sentence, Judge.
I'm sorry.
Determinate sentence.
Okay, so usually they have more information because they talk to probation, and that's how everyone gets information. So I'm gonna recall this. All right, I'll recall this for March. The week of March 10th is spring break. So I'll recall it for March 6th. Is that enough time for everyone to have everything?
Judge, I was gonna ask the court if you would entertain a motion for a transcript of his plea as well, because there may have been
Well,
this.
I mean, let's see what they have first. And then I'll entertain all motions if you want to bring your motions on that day.
Okay,
I'm sure,
I just don't want to delay it further by
No, no,
bringing
no.
up that motion later.
I am sure, and I'm not putting my thumb on this scale. There are some attorneys where I can say, maybe we need a motion. I honestly don't think you will need a motion. He's gonna look into it, and if they have it, he'll give it to you.
Yeah.
If they don't, or if legal, he's allowed to give it to you, he'll give it to you. If not, you can file your motion, and then we'll go from there.
Well, what I'm talking about in terms of the plea judge, you know, sometimes when people go before the bench, there's discussion about the case, there's,
Oh, he's gonna find that information out.
well, but I'm talking about a motion for a transcript. Where the court will allow me to get the court reporter to transcribe the actual plea.
He's gonna find out if that happened, but if nothing was said at the plea, other than this is the plea, then there may not be a need of transcription. It may just be, what's the plea bargaining agreement? So let's see what information we have. And then go from there.
I know, Judge, but,
All right, because I don't like to waste money.
well, my
It's
guy's
just me.
facing a life sentence. I don't think it'd be. a-
No, I understand. I just don't like wasting money unnecessarily. So we will see. If it turns out that there was something that was transcribed and something was said and they actually had a hearing where witnesses took place, guess what? I'm gonna make sure you get that.
Sure.
Okay? So you don't have to worry about that. So we're gonna bring it back on March sixth. Do you have any questions about anything?
No.
All right, so we're gonna bring you back on March sixth. Trust me, your attorney is not going to go to trial if that's what ultimately ends up happening without information that he needs or he feels he needs, okay?
Thank you.
All right, thank you. Thank you for addressing appropriately for court. Once you sign the reset form, you're excused. And if you, do you need copies of this?
I'll take some.
All right, so if you'll make the copies and then bring it back to me so I can put it in the system. All right, do you have any questions about anything?
No, Your Honor.
All right, if you'll have a seat, they'll bring the reset form to you.
Thank you, Your Honor.
You're welcome. All right, who's on Tyler Ketchum? Yes. All right, so we're here for a contested.
I think we have that worked out, Your Honor, or we do not need to have it contested hearing.
Okay.
I think,
Yes, ma'am.
well, to begin with, this was, Mr. Ketchum had just begun supervision.
So is this a plea of true or what are we doing here?
If Mr. Ketchum agrees to the supervision office's recommendation, the state will withdraw the motion, and it seems that Mr. Ketchum will agree with the supervision office's recommendation.
And what is the recommendation?
Allow to close interest in veterans court referrals, set compliance hearing for 60 days to ensure probationer is complying with remaining assessments and referrals.
All right, so Veterans Treatment Court, do they want him?
Judge, they have closed the case out. There was a little pushback in regards to having the evaluation completed. Mr. Ketchum feels that he doesn't need the Veteran Treatment Court services at this time.
All right, so didn't I order that? Who ordered Veterans Treatment Court?
I believe that came out of whenever the plea was originally made, because he does have, he is a veteran. The plea was entered in front of Judge Maheta.
All right. So why are you not participating in Veterans Treatment Court?
I've understood that I was under probation through the current process. They told me that it would take 2 years to complete the Veterans Treatment Court, which is unacceptable. I'm trying to get into it. Perfectly
No, it's gonna have to be acceptable. Here's the thing. This is what I tell people all the time. If everybody could write their own program and be successful at it, none of us would have a job because everybody would be writing their own program and they would not have cases. So is Veterans Treatment Court going to take him? Because it was a referral to Veterans Treatment Court. Are they going to accept him?
Judge, Mr. Herman is on his way now.
All right, so let's see if they're going to accept him. All right, thank you. All right, court is calling 2025 CR 0014448W State versus Victoria Lopez. Can I have parties announced for the record for the state
Andrew Harris Sadelman.
defense?
Doug Campbell for Ms. Lopez.
And are you Ms. Lopez?
Yes, ma'am. Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Lopez, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney? Did
Yes,
you
ma'am.
understand it?
Yes, Your Honor.
That's one moment. All right, so we can go off the record. I don't have the waiver.
Shoot. I'll get it, Judge. I don't know if that's something.
It's something for the state to print out. It's the waiver 101.051. Did y'all print that out? Because this is a waiver case, correct? All right. So that's what I need. So if you have a seat, your attorney's going to go over that document with you.
Yes, thank you.
All right, thank you.
Your Honor,
Yes,
may I approach?
yes,
What I tell you.
yes.
It's at the very back.
I don't have it. Sure. Hi.
Good morning, Ms.
Good morning.
Judge Boyd.
Good morning. So, Mr. Ketchum, are you all willing to accept him?
Yes, Your Honor, if he's willing to comply, and cooperate with us, we can screen him for Veterans Treatment Court.
All right, so they're willing to accept you. Are you going to comply?
Yes, Your Honor.
All right, because if you're not going to comply, what's going to end up happening is we're going to be right back here for a contested. And I will tell you, this contract, probation is a contract with the court, not with your attorney, not with the state. So I don't have to sign a motion to withdraw. Do you understand? All right, so probation,
Yes, Judge.
what conditions are you re-adding? Are you adding anything else, or he just needs to comply?
He just needs to comply, Judge. We were gonna ask for a compliance hearing within 60 days. He needs to sign that. I'm sorry, Andrew.
No problem.
We were gonna ask for a compliance hearing in 60 days to make sure that he is where he is, but if he's going to Veterans Treatment Court, Judge, we would ask that we just get a report from them. Also, Mr. Ketchum did some community service hours through
Cortisone Ministries, Your Honor. This is the.
Cortisone Ministries. This is not on our approved list, but we are asking that Mr. Ketchum give you an overall view of what he's been doing there so that you can possibly grant him these community service hours.
All right, what have you been doing there?
They help the disadvantaged homeless in the San Antonio metropolitan area,
Mhm.
some of the like drug affected as well as mental health. So they do case support for housing, food bank works there as well. It's through the Grace Food Bank.
So is that what you've been doing?
Yes, Your Honor.
And it says day center and overnight. What have you been doing overnight?
So this was during the freeze, Your Honor. So they opened up emergency sheltering for the homeless that were in the area whenever it was dropping below freezing temperatures. And I stayed there overnight to help with the rest of the volunteers.
Okay.
That's why the hours are so extended.
All right. Once that's signed by the director, yes, he can have credit for those hours.
Judge, the supervisor did initial, but you want the director to sign off?
Yes.
Okay, Judge. And this is the withdrawal?
Judge?
Yes.
We will need a new order of referral since we did close out the previous one.
Okay.
And then just to be clear, we haven't gotten started on any evaluation process, but as soon as we have an answer, we can report that with the court.
All right. So he's going to be released from custody. So you need to make sure you have their information and make sure that you meet all appointments with them. Otherwise, there's going to be a warrant that's going to be issued because another motion to revoke is going to be filed. Do you understand?
Staying on.
All right. And how long do y'all think it'll take?
So we should have an answer by early March. Unfortunately, we are all booked out for February for the final step, which is the mental health assessment. But by early March, I foresee us having a response
All right.
for this case.
So, Ms. Ferguson,
Yes, sir.
we're going to recall this back on March 17th. Is that enough time?
Yes, Your Honor.
All right, so we're going to recall March 17th for an update on VTC. Probation, is there anything else? Anything else?
No, Your Honor.
All
That's
right,
all
is
from
there anything else you need from the court?
Just to clarify, Your Honor, is he okay to complete the rest of his community service hours with that same?
Yes.
Ministry? Thank you.
Yes.
And we appreciate your acceptance.
All right, you're welcome. So make sure that you follow through with Veterans Treatment Court. You understand?
Understand, Your Honor.
All right. Make sure you have their information. If for some reason you lose their information, you can always come back to court or talk to your probation officer and they'll give you that information.
Understand, Your Honor.
All right, good luck to you.
Thank you, Judge. May we be excused?
Yes.
Thank you.
Have a seat, sir.
Oh, and Norma, he's gonna need a reset form for March 17th. And what page? Just catch him on? Thank you. All right, are you all ready on Victoria Lopez?
Yes, Judge, real quick,
Yes,
may I approach?
yes.
The case today, Sean Kilton, I don't have the page number
Mhm.
memorized, but he has a case that Marshall White has been appointed on, set today. He has another case that is indicted, that has Mr. Scott Hill appointed on, that's set tomorrow. So I've talked to Marshall on the other case, which is the one set today. Does this court mind if this case gets recalled tomorrow, so that Mr. Hill can be here with Mr. White?
Is he in custody?
He is in custody, Judge.
All right, what,
I mean, and that, I got a microphone. What's weird is clearly he's got his own indicted case. I'm not worried on those cases.
I'm sorry, you're what?
Also, wanted to turn on unindicted cases. In this other case, so Scott Hills was one, I don't know how that happened. I think it's better to have one attorney on everything.
All right, Sean Plimpton, or Plimpton, Hilton. I think I said every name but. Mr. Plimpton, come down.
And being judged that he is currently indicted as a habitual, that is above my appointment. That, I mean, I could stay on the case, obviously, with okay, well, Mr. Pickles was okay, I could stay on the case, but that is definitely something I needs to be
All right.
brought forward.
All right, thank you.
Yeah.
So we're gonna bring you back tomorrow because you have another case that's set with us tomorrow. Do you understand?
Yes, ma'am.
You have any questions?
Mhm.
All right, Ms. Ferguson, if you're recalling for tomorrow, thank you all.
Thank you, Judge.
Thank you.
Good to
Have a
see you.
good one.
You too. I wore purple.
Oh, thank
I
you.
want to talk to this guy before he goes back.
Anything else?
My mom will say like, oh, Hunter.
Good.
Okay, so we coming back tomorrow, this guy?
Thank you. See you tomorrow.
All right, tomorrow?
Yes, sir.
And Scott Hill's gonna be here?
Yes. All right, we're back on the record in 2025 CR 001448W. So Ms. Lopez, did you have a chance to review with your attorney the documents? And let me see where that document is. Thank you. The document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure.
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you understand that your attorney has certain rights, as do you? And those rights are to have this case brought before a grand jury for the grand jury to make the determination whether or not there is enough evidence to hold you open for trial?
Yes, Your Honor.
Did you also understand that your attorney has certain time conditions that are related to your due
Yes.
process, namely 2 days from the presentation of the information?
Yes, Your
So
Honor.
2 days to expire once he's presented with the presentation of the information, and also 10 days to prepare for trial. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand it?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Did you review the admonishments with your attorney? Did you understand them?
Yes, Your Honor.
And did you sign it in all the appropriate places?
Yes, Your Honor. I did.
Did you understand you're charged with possession of a controlled substance penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state recommends deferred adjudication. This will run concurrent with County Court Cause number 724150. They are taking into consideration 2024 PF 27235, 2025 CC 000769. Did you understand that to be the plea?
Yes,
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Contained in Exhibit 1 and attachments.
No objection.
All right. State, you have the dismissals for me, and after that, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor. I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes,
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge Victoria's, obviously she's got an addiction. She'd like to get an assistance for that addiction, but she also has 5 children under the age of 18 that she cares for. She's got a job at an insurance company, and she would like a chance to continue her life out there in the world. With that in mind, I know the court is going to order a TAP evaluation, and we'd ask that the court allow her to do the TAP evaluation out there.
So who are your children with now?
My mother's currently watching. 4 of them have graduated already.
Okay, so what are your children's ages?
I have the oldest is 21, 18, 20. My 17-year-old graduated early. And then the ages 2, 8, 14.
All right, so has Child Protective Services been in your life?
Yes, they have.
All right, so did they place your children with your mom? That's either yes or no.
Yes, ma'am. Well, yes, ma'am.
All right, have your rights been terminated?
No, ma'am.
So why were you with this guy? And this is from, I guess, 2023? So why were you with him?
This is a bad mistake. that
No, I mean,
made.
these are choices. Did
Yes,
he
ma'am.
force you to be with him?
No, ma'am.
So that was a choice you made to hang your star to him.
Yes.
So why would you be with him? And you have children?
At the time I was homeless at that time. I do have an apartment now. I've had an apartment for about 4 months now, and I've come a long way from that time of my life.
So who lives with you at that apartment?
Currently me, my 14-year-old. That's all.
Because,
That's all, ma'am. Just me and my 14-year-old.
and why were you stealing at Melrose?
I needed some clothes.
And when's the last time you used?
Last time I used, when I had got caught, my last conviction, maybe about 3-4 months ago, 3 months ago.
Judge, I think she means her last arrest, not conviction.
No, I'm sorry, my last arrest. Yes, correct.
So your last arrest was 3 or 4 months ago,
Yes, ma'am.
and and that's the last time you used.
Yes, ma'am.
So the only time you have not been using is when you've been in custody.
No, I would use recreational, off and on.
All right, so when you're in custody, I mean, I know sometimes people make things at the jail, but you use when you're not in custody.
Yes, ma'am.
All right, so this is the thing. I need you to be 100% honest with me, because if I grant your application for deferred adjudication, if you're unsuccessful and a motion to revoke is filed, you're looking at 2 years in the state jail facility. I want you to be successful. Obviously, the state and your counsel wants you to be successful. So what have you been using in the past?
I use, methamphetamine.
And what else?
That was it, ma'am.
And how often were you using?
Recreational once or twice a month, maybe not.
All right, see, once or twice a month does not result in you stealing clothes at Melrose and having drugs in your bra. So, I mean, it's more than once or twice a month,
No, ma'am.
because otherwise CPS would not have been in your life. So
CPS wasn't, I'm sorry,
was CPS in your life for drugs and everything
No, ma'am.
else? Why?
it was an abusive relationship.
All right, see, people always say that, but I do know that CPS will not, and you've done CPS, CPS is not removing children from your custody or allowing your mother to take your children because you're being abused. Either they're removing them because you decide that you're going to stay with that guy and not put your children first, or either because there's drug use. But if you have an issue where you're in an abusive relationship, CPS will help you out of that abusive relationship. But if you choose to stay and choose the man over your children, that's when children are placed somewhere else.
And also for stability, I didn't have no form of stability. No, I was homeless.
No, CPS will help you get housing. Your attorney will tell you that.
They, I'm sorry, ma'am, but the CPS worker said that she was not allowed to help with housing.
No, that's,
That is true, actually.
Yes.
Well,
They can
no.
help get them on the list, but that's
they
as
will
far as
get
they
them
go.
on the list.
She said that, I'm sorry to interrupt, ma'am, I don't mean to do that.
No, no.
She said that she was not allowed to, she has no strings in that department.
They do if you're in their children's court for addiction.
One question, Judge.
Yes.
Did they ever file a suit against you to terminate your parental rights? Or did you just work with family-based?
I work with families.
Okay.
Okay. All right, this is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. There's to be no contact with Melrose store if they're still in existence. And there's to be no contact with Anthony Reyna, Reyne Cantu Jr. There's going to be a TAP evaluation and a felony drug court referral in custody. Counsel, the felony drug court, they'll see her before the week is out.
Okay.
There should be regular reporting by Zoom or in person. There should be regular random UAs, proof of employment within 30 days. There should be no employment as a home health care provider or with minors. There should be no unsupervised contact with minors. There should be 200 hours of community service restitution. Once parenting classes are completed, 100 hours be deducted. How far did you go in school?
I graduated. I have a high school diploma.
All right, what are you planning on doing with your life?
I plan on going to go, apply at Toyota and UPS.
Okay. All right. So I'm going to require parenting classes. Once she completes parenting classes, 100 hours of community service will be deemed satisfied. I'm not going to order you to go to a trade school or obtain a higher level education, but if you do, if you get your CDL license or something of that nature, then the remaining hours will be deemed satisfied. There's going to be field visits 1 time per month until further notice. Probation, is there anything else she needs?
Okay.
Is there anything else you need from the court to be successful?
No, ma'am, I really appreciate this.
All right, thank
opportunity.
you. And probation, I'm sorry, I'll add 60 sober meetings in 60 days. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. In this court, communication is key.
Yes.
In order to be successful, talk to your probation officer. Before parties leave, if there needs to be copies made, you can make copies in back of the record. So the court will grant the motion to unseal the record of Ms. Reyes' sentencing. And my understanding is that the court reporter has made a, yes,
The plea colloquy, we haven't done sentencing yet.
yes, oh, sorry, thank you, of the plea. So the court reporter All right, we're going to come back on March 20th. State at that time, you will need to be prepared to tender an offer.
Yes, Your Honor.
All right, is there anything else?
No, thank you, Judge.
Do you have any questions, sir? No questions? All right, thank you. We'll see you back on March 20th. Thank you.
Thank you, Jeff.
All right, and then my understanding, we have one more. Yes. Yes.